Hey, excuse me, Hilton. They told me to let you know they're ready to get started.
Okay, just a minute. I'm just putting my face on.
Welcome, Chief, Deputy, Assistant, District, Special Ops, Attorney, Fumble Lips, Slip-On Hilton. And welcome, Chief, Double Deputy, Assistant, District, Special Ops, Attorney, Lion-Ass Lawyer, and a Dreamland No Love. I'm Phony. This is Fonny, Fanai, Fanye, Fawny, and Phoebe. We're the fanny pack. Welcome, ladies, to the fine art of Brady. Suppression. Today, we're gonna learn how to keep those pesky defense attorneys in the dark.
We're ready.
Now, Attorney No Love and Attorney Slip-On Hilton, let's start with the basics. What is Brady evidence?
In 1963, the Supreme Court of the United States heard the case of Brady v. Maryland, which dealt with the issue of prosecutors withholding evidence that could potentially exonerate a defendant or lessen their punishment. The defendant's lawyer requested access to the accomplice's statements, but a crucial statement was withheld by the prosecution until after the trial and sentencing had concluded. The central issue was whether this restriction violated the defendant's constitutional rights. The Supreme Court, in its decision, upheld the Maryland Court of Appeals ruling that the suppressed confession would not have reduced the defendant's offense below first-degree murder. The court determined that denying a retrial for guilt did not violate equal protection and maintained that the petitioner should receive a new trial concerning punishment only, not guilt.
What is Brady evidence?
Evidence favorable to the defendant that the prosecution must disclose.
Excellent. Now, how do we prevent that evidence from ever seeing the light of day? First, we misplace it. A little accidental loss never hurt anyone. Or we can bury it deep in the bowels of our file system. And if all else fails, what I had heard was our system got hacked.
But what if the defense requested?
Well, No Love, that's where the delay tactics come in. We stall. We obfuscate. We create roadblocks. By the time they get their hands on it, the trial is over and they're too tired to fight it.
But what if the defense find it anyway?
That's when we employ the damage control. We spin it, blame it on the defense, or simply deny its significance. Remember, ladies, confidence is key.
Technique 1. The art of misplacement.
Now, let's talk about misplacement. It's an oldie but goodie. You see, evidence has a funny way of wandering off. A misplaced file, a lost hard drive, or even missing police reports. The key is, if you don't write nothing, you don't got nothing. It seems accidental, but the result is golden. Now remember, Chief Deputy and Chief Double Deputy, the more complex it is, the easier it is to hide a needle in the haystack.
What if the defense asks for discovery?
Good question. We create a generic log filled with vague entries. The less specific, the better.
Is there a risk for getting caught?
Well, of course, there's always a risk, but if done right, the chances of getting caught are slim to none. And remember, the ends always justify the means.
Technique 2. The black hole of delay.
Next up, Technique 2, the black hole of delay. This is a delay tactic. This is where patience is your greatest weapon. When the defense requests Brady material, we hit them with a barrage of objections, motions, and appeals. We tie them up in knots until they're begging for mercy. Remember, if you give it to them before the trial is over or before the judge rules, then it's not Brady anymore. Then by the time they finally get their hands on the evidence, it's too late. The trial is over. Or they're so exhausted they don't even have the energy to fight it. It's beautiful.
How do we avoid accusations of prosecutorial misconduct?
The key is plausible deniability. Blame it on overworked staff or on a clerical error. Never, ever admit to any intentional delay.
Now, what if a judge get impatient?
A little flattery goes a long way. Remind the judge of their busy schedule and how your delay is actually saving them time in the long run.
Technique 3. The spin doctor.
The next technique, number 3, is the spin doctor. Now let's talk damage control. If, by some miracle, the defense actually gets their hands on the evidence, we can go on the offense. We spin the story, blame junior staff, or claim the evidence is irrelevant. And don't worry, the judge will usually jump in here. Remember, confidence is key. If you act like you're in control, people will believe you.
Excuse me. What if the evidence is too damning to spin?
Well, in that case, we resort to plan B. Discredit the witness, attack their credibility, and hope the jury doubts their testimony.
Isn't this unethical?
Ethics are for amateurs, ladies. This is about winning.
Technique 4. The nuclear explosion.
And finally, technique 4, the nuclear explosion. Now, if all else fails and the defense is relentless, we have one final weapon, the nuclear option. We lock up the defense attorney, a little contempt charge here, a sneaky remark there, and boom, they're behind bars. The message is clear. Mess with us, you pay the price.
Isn't that a bit extreme?
Well, sometimes desperate times call for desperate measures. Besides, it sends a powerful message to the other defense attorneys.
What if the judge doesn't cooperate?
Don't worry about the judge. If he slips up, I'll remove his ass faster than I put him in that seat. A little persuasion might be necessary. A friendly reminder of their career aspirations could work wonders. Don't worry, I'll handle that part. And there you have it, ladies. The complete Brady suppression playbook. Master these techniques and you'll be unstoppable. And remember now, the justice system is ours to shape.